this matter seems to be a gray area. Pero ito pong pananaw ko. The position that the only exception to the rule of confidentiality of those records is kapag ang Congress, ang House, ay nag-request in aid of legislation, but subject to that limitation that it should be an executive session, actually renders our role in an impeachment case, in an impeachment proceedings, inferior to that role as a body with legislative functions. Because ours, when sitting here in an impeachment proceedings, is a special constitutional duty. So hindi po katanggap-tanggap sa akin na ang sasabihin po ngayon ng the Honorable BIR Commissioner na babawiin na lang namin ang kahon na yan kasi nga hindi siya sakop sa exception, which is when mag-request in aid of legislation. When our role sitting in an impeachment proceedings is a special constitutional duty. It is superior to that as when we are acting merely as a legislative body. Yun po ang aking position. But of course, the issue of cautiousness is another matter. Kaya nga ho tinatawag kong gray matter po ito. Pero insulto po sa House through this committee in an impeachment proceedings na sasabihin na ito, dahil hindi ito in aid of legislation, ay hindi tayo sakop ng exception, even if hindi nakalagay sa batas. Tungkol lang yun sa pag-request. But sabi nga po ni Congressman Ridon, sabina po ito, hindi po ito ordinary request from the House of Representatives. So yun po ang aking posisyon.
Madam Chair.
We commend all the meaningful and vital opinions of the Justice members. We've been here for 8.5 hours already. Just to remind all of you, no? And I think we are very much divided with regards to the question of whether we will be opening this or not. But definitely, please join me, my fellow members. We will not be returning this to BIR. The only issue is whether or not we will open the same. Can we defer the resolution of this issue? With the indulgence of my fellow members, with the indulgence of Commissioner Mendoza, hindi po namin ito ibabalik. Batid po namin kami confronted ng question kung maari ba namin itong buksan o hindi, pero mas mamarapatin po naming alagaan ang kahong ito kahit po ito'y selyado. Habang amin pong pinag-aaralan ang tamang posisyon ng Justice Committee kung bubuksan o hindi. Having said so,
I move that we lay on the table the opening of the contents of the said box until we find the true legal position and avoid any constitutional constraints moving forward. So move, Madam Chair.
Madam Chair.
there is a motion
Madam
to
Chair.
lay on the table the opening of the box. The same has been seconded. Honorable Rufus Rodriguez.
Yes, Madam Chair, this is a very difficult question of law. It involves the philosophy of law. There are two kinds of interpretation when there are two conflicting laws. Whether you are in the positive school, that is Justice Scalia of the Supreme Court of the United States, or you belong to the spirit of the law school. Now, Mr. Chairman, in the positive school of law, that is precisely what the National Internal Revenue Code says. In the positivist approach of law, and lawyers will know this because you all took up theory of the law, it is you confine yourself in the four corners of the positive law. That is positivism. Correct, Commissioner? Because you're a lawyer. And so you took a philosophy. What law school did you go to?
I'm a product of San Beda University.
Oh, very good law
College
school.
of Law.
So therefore, in the positivist school, this is an issue on whether the NIRC, in the four corners of the NIRC, the National Internal Revenue Code, it is clear there that it can only be done in aid of legislation and in executive session. So that is the positive law. In other words, if you follow that trend of law, there can be no opening of this because we can never convert ourselves into an executive session or an aid of legislation because you have another function right now, which is impeachment. Now, what do you say about that positive school of thought? Because these are the final points, Mr. Chairman. What does the lawyer from San Beda say? Because we now have this. Because I will then ask you, the other law or rules that will govern this is the rules of impeachment, which has the effect of law, which provides that there is absolute power. The power to issue the subpoena ducis tecum. And the spirit of the law is accountability. So we go to the spirit of the law. We have to use, therefore, our rules that says the committee, the Justice Committee acting as a impeachment court can subpoena you to submit. So which one now would you agree? The positivist school of law or the spirit of the law? So in other words, your NARC or for our justice members, the spirit of the law. That this is different. This is sui generis. We have given so much power because this is accountability of very high officials. So which one would you now say that governs? Because you are a lawyer. Is it the positivist school or the spirit of the law school? Rules of impeachment, NARC, which will now prevail?
Would you like to answer, Commissioner Mendoza?
Madam Chair, for now, I am taking the conservative view. We will abide by what the law expressly says.
Very good answer, because precisely Justice Scalia is the positivist in all history. Scalia, who died of the Supreme Court, only would, if there's any issue, you go only to the four corners of the law. You do not go to the spirit of what is said there. However, you also have a situation where we have the power. This is a sui generis. And it says it can subpoena anyone and any document. And this is sui generis. What do you think about that? So once again, you're saying, what do you say?
Honorable Rodriguez, let us be conservative for now.
You know what I mean? It's very good discussion because now many lawyers are watching us. The people are watching us. We have to therefore be able to have a decision on this because, as I have said, there are now two contending schools of thought. The philosophy of the law. I was under Professor Espinosa in UP, and we discussed this. So, positivist and the spirit of the law under our rules. What do you think should be your answer?
Actually, we have complied with the subpoena, Madam Chair. We have in fact submitted the documents, subject only to the conditions provided in the law. We have no intention to not comply with the directive of the committee, as in fact we did by submitting the documents. Our only request is that we examine the documents within the bounds provided by the National Internal Revenue Code. Thank you, Madam Chair.
And that would mean, Madam Chair, that the Commissioner is saying that since he has stated this earlier, that because it is not an aid of legislation, then that will not apply. Correct? In other words, you're saying that even executive hearing does not apply because this is not in aid of legislation.
Yeah.
It's not a hearing.
As I have said, Madam Chair, when we submitted the documents, our premise is that this proceeding is also in aid of legislation because whatever may be discussed here could be the basis of a future amendment of a law. Like, for example, as I said, the bank secrecy law or probably the tax code itself. But if the committee itself says that this is not in aid of legislation, then we will have to abide by that.
Very good lawyers from San Beda. That is why I would support now that we lay on the table so that all of us will study.
Now let's rule on the motion.
Because let us all study now.
There is a motion to lay on the table.
Madam Chair,
The
before
same
that,
has been seconded.
before that, Madam Chair, just one question for the Honorable Commissioner.
Please
Dun po
proceed.
Doon po sa natanggap nyong subpoena, nakalagay ho ba doon na ang pupuntahan yung hearing is in aid of legislation? O alam nyo po na ito ay impeachment? This is an impeachment proceedings.
Yes, alam po namin na ito ay impeachment
And yet,
proceeding.
you still produce
Yes, opo, sapagkat
because you are compelled to do that,
sapagkat
to produce.
sapagkat meron pong direktiba ang committee na isabit namin ang mga dokumento at sa paniniwala namin nung isinabit namin ang mga dokumentong yon ay kung anuman ang mapag-uusapan dito ay po pwedeng maging basis ng future legislation. Kung kaya't ang tingin po namin nung isinabit namin ang mga dokumento, bagamat ang pangunahing layunin ng committee ito ngayon sa proceedings na ito ay i-determine kung may probable cause against the Vice President to go to an impeachment trial, tinitingnan po rin po namin na ang proceedings po na ito ay in aid of legislation.
Pero yung paniniwala nyo, in aid of legislation.
Opo yun.
Pero hindi, malinaw po na this is not in aid of legislation because this is an impeachment proceedings, di ho ba? And you produce the document because we're ordered via subpoena.
Produce the documents because we were served the subpoena and we believe that the submission is one of the exceptions provided by law.
Kasi ang paniniwala nyo in aid of legislation.
Yes po, Madam Chair.
Pero maling paniniwala po yon because this is clearly not in aid of legislation. Impeachment po ito. Di ho ba? Impeachment proceedings. In any case, Madam Chair, I know that there is this motion to lay on the table, but let
Yes.
me just state for the record.
Yes.
I take the stronger legal position that Congress, in its impeachment capacity, can compel production of ITRs of the impeached official. The constitutional accountability imperative and the doctrine of constitutional supremacy over ordinary statutes support this view. The NIRC's confidentiality provisions do not immunize a public official from disclosure in a constitutionally mandated accountability proceeding. Yun po ang pagkakaiba. This is constitutionally mandated accountability proceeding. Special po ito. Sui generis po ito. So, hindi ho pwedeng ma-immunize ang isang impeachment official dahil lamang merong ganyang confidentiality provision in a statute. Constitution prevails over an ordinary statute. That's my position. Thank you, Madam Chair.
The committee notes all your important positions and opinions. I just wish to remind all the members that let us maintain the caution that we have started since day one of our proceeding. We owe that to the sovereign Filipino people to make sure that we move forward in this impeachment proceeding and we will not be a subject matter of another petition before the Supreme Court. With that, let us rule on the motion. There is a motion to lay on the table the opening of the box. The same has been seconded. Is there any objection? Are you objecting, Honorable De Lima?
Yes, because of that's a position that I laid down. The latest position that I laid down.
An objection has been registered to the motion to lay on the table the opening of the box. Let us now divide the House. Those who are in favor of the motion, please raise your right hand. Thank you. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. Thank you. Comsec, please submit the result of vote. Those who abstain, please raise your right hand. No one abstains.
No abstention.
With 21 votes in the affirmative, 4 votes in the negative, and 0 abstention, the motion to lay on the table the issue of opening the box is hereby granted.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Adjong and then the Honorable Sendanya.
Yeah, Madam Chair. I hope we are in understanding and agreement that we will not send back this box to the to BIR. Tama po ba? I don't need to make a motion on that. Should
Commissioner, I hope you defer to the committee on its position not to return the box. We will keep the box although the same is sealed.
Yes, Madam Chair. We defer to the decision.
Okay, thank you, Madam Chair.
Madam, on a related point, Madam Chair,
Honorable Sendanya.
perhaps for